Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, flu season is upon us, and I got an email the other day that I wanted to share with you. And basically, the email asked me, can you require flu shots for your employees? And quite frankly, I didn't know the answer to that. So, as usual, I did my little research and captured some things, and I'll read some of this to you and discuss some of this with you. All right. So, can your employer require flu shots for your of their employees? Well, I can tell you there was a hospital that was sued by the EEOC. It was actually in federal court, and over allegedly firing 6 employees after it denied their request for a religious exemption from the flu vaccine. Now, according to the complaint, this particular employer, which was a hospital, by the way, that they maintained a policy that provided that exemptions for medical or religious reasons allowed employees to wear face masks instead of receiving the vaccination. But it denied the exemptions in the case of the 6 employees who were fired. Now, that's ridiculous to me. If you already had a policy in place, I'm not sure what their thinking was. So the general question, can you require your employees to receive a flu shot as a condition of employment? Well, according to the EEOC, they said the answer is yes, that you can require a flu shot for your employees. Now, that really surprises me with the EEOC, all right? But they say that an employee may be entitled to an exemption from a mandatory vaccination requirement based on the ADA disability that prevents them from taking the influenza vaccine. This would be a reasonable accommodation barring undue hardship, significantly difficulty or expensive. Similarly, under the Title VII of the Civil Rights of 1964, once an employer receives notice that an employee sincerely held religious beliefs, practice, or observance prevents him or her from taking the influenza vaccine, the employer must provide a reasonable accommodation unless it would pose an undue hardship under Title VII. Now, what's interesting about this is that I have no problem with that. According to the EEOC, an employer can actually require the employee to get flu shots. Now, why would an employer want to do that? Well, logically, they don't want the people out sick. They don't want to use the sick days, or they want them there to do the work that has to be done. If a person comes to work, and sometimes people do this, they come to work even when they're ill. And now when they come there, let's say they've got the flu because they didn't get the flu shot, then they spread that flu to other people, and now your staff ends up being, a significant number of your staff ends up being catching the flu and now being out sick, so the work doesn't get done. Now, people always want to talk about the fact that, the employer's interest versus the employee's. Look, listen, a business is a business. They need their employees at work in order to establish and maintain that business. Now, people getting upset with the kind of thinking about giving them days off, doing this, people being away from work. Just think about something. If the employees are not there to do the job, the business can't maintain in the long run. That means they can't pay their salaries. So, to me, having a policy in place, and again, I didn't know about this one until this question was posed to me. Can you require them to get the flu shot? The answer is yes, according to the EEOC. So I find that very interesting. I don't think that I would ever make my employees take a flu shot. I know that I didn't like the idea of a flu shot. My doctor, I don't know, I've had him for a number of years. He finally convinced me to get one. I always had this concept that if I got a flu shot, I'd get the flu, because you've heard stories about people getting the flu after they got the flu shot. Well, once I did the research on it, I found out that that's not it. They may already have been getting the flu. They got the flu shot, and the flu just manifested itself. So now it looks to them like they got the flu after they got the shot. May not necessarily be true. But I went ahead and got my flu shot, and that was now probably about, 5 or 6 years ago. And quite frankly, knock on wood, it has worked out just fine for me. I've not gotten the flu. But then in all honesty, it was very rare that I got the flu before anyway. But it is what it is. But while I'm talking about this in terms of flu shots, people being out sick, and I'm talking about this on a federal level because I mentioned about the EEOC, we're still getting calls regarding the sick pay for people and these sick days. The California as an example, so I'll take it down from a federal level to a state level, where people are asking about these sick days that their employees can take off, the mandated sick days for California. Look, the calls that we get are calls where people are upset that the person is taking off may not actually be sick. Do me a favor, don't worry about that. If they want to use their sick days up during the summer because they're out there good timing it at the beach or whatever it is that they're doing, and once they use those mandated sick days, that's it. Any other time that they take off, you can reprimand them for the additional days above the mandated sick days, and they don't get paid for the other days if you don't have sick days and paid sick days above the mandatory sick days. So, stop worrying about whether or not they're actually using the days properly or not. That is completely on them. You're not going to be able to monitor it and have, someone go around and monitor who's actually taking off a sick day because they're sick. So why waste your energy on that? All right. So I just wanted to kind of throw that in there regarding, since we're talking about the flu and people being out sick and everything. Don't trip it. Now look, there was another issue that came up that I wanted to discuss with you. And that had to do with whether or not an employer can take overtime credit for paid lunches. The issue came up as to, and hear me carefully on this, whether or not an employer can take overtime credit for paid lunches. Now, what do I mean by that? Well, first of all, let's talk about it. The Fair Labor Standards Act does not require paid lunches. Now, again, I'm on a federal level here for my national people here. Does not require paid lunches for employees. All right? Now, what happens, however, to an employee's overtime compensation if the employer pays an employee for non-working lunches? Pays the employee for non-working lunches. In other words, everybody gets a paid lunch. All right? So you come in and you're going to work. I'm going to pay you for all hours you're on my company premises. But now you have a day where the individual works over 8 hours in a day. So the person is there 9 hours. The question that was raised with the court was whether or not I can take the 30-minute lunch that I gave them paid, and it was a non-working lunch. Can I take that 30 minutes and apply it towards 30 minutes of the extra overtime that the person worked? And according to the court, the answer is no. Now, this was a federal case. Now, the court pointed out that the Fair Labor Standards Act only permits employers to take an offset against overtime under 3 limited circumstances. This is important. 3 limited circumstances, each which involves some component of premium pay in excess of an employee's regularly hourly rate. Here are those 3. 1, extra compensation provided by a premium rate paid for certain hours worked by the employee in any day or work week because of hours worked in excess of 8 hours in a day or in excess of an employer's defined maximum work week. Extra compensation provided by a premium rate paid for certain hours worked by the employee in any day or work week because of those hours that are worked in excess of 8 hours in a day, defined by the maximum work week. So what they're saying is that there can be an agreement whereby this is the rate based upon the hours that you work. I hesitate with that one because I think employers are going to abuse it. All right. Number 2, extra compensation provided by a premium rate for work by the employee on Saturdays, Sundays, holidays, or regular scheduled days of rest, or on the 6th or 7th day of the work week, where such premium rate is not less than 1.5 times the rate established in good faith for like work performed in non-overtime hours or other days. Again, we're talking about extra compensation. All 3 of these are talking about extra compensation with the understanding with the employee that you are receiving extra compensation to cover overtime. The third one, extra compensation provided by a premium rate paid to the employee in pursuance of an applicable employment contract or collective bargaining agreement for work outside of the hours established in good faith by the contract or agreement as the basic normal or regular work day, not exceeding 8 hours, or work week, not exceeding the employer's defined maximum work week, where such premium rate is not less than 1.5 times the rate established in good faith by the contract or agreement for like work performed during such work day or work week. What does that mean? Once again, now you're talking about a contract, or you are talking about the bargaining agreement, which means that the union has said, okay, it's okay to do it this way. All of these are based on extra compensation that the employee is going to receive, knowing that they in fact are going to work a higher work week or work day, whatever the case it may be, and it's been established. So those are the only three circumstances. Personally, I think employers need to be careful about that all the way down the line. I think that as a rule, you need to just turn around and say, you know what, I'm going to pay you in excess of all hours worked and let it go like that. I just think that that's the best policy. Because again, I'm giving you something on the federal level. You got to be careful because each of the state laws may be different. All right, with that last comment, it's time to close out the segment. But let me remind you, you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. Or you can email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.